Hi, in today's presentation, I'm going to assist you through the process of understanding EU law and the Court of Justice of the European Union. In order for the EU to function properly, the states sometimes need to accommodate and adjust some of their freedoms, especially when it comes to the determination and application of public policy. One of the areas in which this happens is the area of the EU legal system. To put things briefly, the EU law developed throughout time a higher status than the national law. In general, the law is there to help clarify relations between the institutions and between the institutions and the member states, to help clarify and extend EU policy in many different spheres, and to help develop and maintain the EU spirit. For this presentation, I will draw a comparison between the national democratic states and the EU. I'll present you the critical points about the EU law and the types of law and their characteristics. I'll introduce the role of the European Parliament in legislation, the role of the Court of Justice of the European Union, which is split between the Court of Justice and the General Court, and then I will introduce some subjects for discussion in class and in my references. So, in order to better understand this aspect, I drew a comparison between a national democratic state and the EU. When it comes to the legal framework, this is an essential component of the democratic state when it comes to decision making and decision application. Although the EU is itself not a state, this also applies to it because national states have voluntarily surrendered most of their rights to be independent in the determination and application of public policy. Therefore, the EU law became a critical component in ensuring that everything works properly, both on the level of the institutions as well as when it comes to the member states. For instance, it regulates the ability of the Council and the Parliament in determining the EU's annual budget, but it also covers the intergovernmental agreements. It is crucial, therefore, that the common laws can be interpreted in a uniform manner by all member states. Then we have the aspect of the Constitution. For the EU, we have two very important treaties. We have the Treaty of the European Union and the Treaty of the Functioning of the European Union, which constitute, in a way, the roles of the EU Constitution. In addition to them, the court judgments and the interinstitutional agreements are part of an ongoing constitutionalizing process. The first two aspects of the treaties cover the main roles of the national constitutions. First of all, we have institutional decision making. So these treaties identify, describe, and define the relations between the Commission, the European Council, the Council of the European Union, the Parliament, and the Court of Justice, and as the key decision-making institutions. Secondly, we have the individual freedoms and liberties that are covered in these treaties, which are also found to be found in the national constitutions. The treaties themselves tackle more the economic freedoms and liberties. However, there are supplementary mechanisms that ensure that the other types of rights are respected. For example, the Charter of Fundamental Rights of the EU. Thirdly, in addition to a normal constitution, they also regulate policies. They identify the policy sectors and direct their development. So, in a nutshell, the general principles of the treaties are in a way translated by the EU institutions into specific rules, just as the state institutions apply the national constitutions. These laws are adopted by the European Parliament and the Council, by the Council or by the Commission, the first two being concerned with broader and more important matters. Now to the EU law. It is defined as an autonomous legal system, imposing obligations and rights on both individuals and member states. It has two types of law, primary and secondary, the primary to be found in treaties, so the one I talked about earlier, and the second derived from the treaties and made by the EU institutions. There are two main pillars to the legal system, direct effect or direct applicability. This means that certain provisions of the EU law can confer rights or impose obligations on individuals that national courts are bound to recognize and enforce. Then we have primacy. Until the Treaty of Lisbon, which brought major changes to the legal framework, there was no explicit reference in the treaties to the primacy or supremacy of the EU law over national law. However, this changed as it ensures conformity, uniformity and consistency in the legal order, because otherwise the state could just annul any type of law that might be inconvenient to them. There are three key points to keep in mind about the EU law. First of all, it is not as wide-ranging as the national law, so it does not deal with matters of criminal law or education, and it is primarily concerned with areas of economic activity. Second of all, in all policy areas, it stands side by side with the national law, so it complements it by adding general regulations to areas where national laws already exist. Thirdly, the range of EU law has broadened considerably over the years. It is desirable as this leads to the uniformization of many fields of activity when it comes to, for example, safety, education, market regulations, and so on. Now, more about secondary law. According to the TFEU, there are five kinds of instruments that make it up. We have regulations that need to be applied on a union-wide level and are fully binding, and they are concerned with highly specific adjustments to the existing EU law. Then we have directives, and the difference in practice between these two is not very easy to make. However, in theory, directives are only binding in their outcome, not in their general application, and they do not need to be applied by all member states. Their incorporation is made through national measures of individual choice. Then we have decisions. They are rather more administrative than legislative in their nature, and they can be adopted in a wide range of circumstances. They may be addressed to all member states or to individuals and so on, and they are binding in their entirety upon those to whom they are addressed. Then we have the soft law, which is made up of recommendations and opinions, and they have no binding force, but they do have legal effects, supporting legislative processes, promoting coordination, and encouraging harmonization. There is generally an ongoing process of simplification of the legal framework in order to make the implementation easier and more organized, and the legal system more accessible. Now I would like to talk about two major institutions that play a role in the EU legislation: the EU Parliament and the Court of Justice of the European Union. Andreas is more about that at the European Parliament in his presentation. So the role of the European Parliament, and even though its powers are not as strong as national legislature, its influence is exercised in three main ways: through legislative processes, sometimes in participating in policy discussions, sometimes by formally adopting its own ideas for suggested legislation, and through Article 225 of the TFEU, the EP can request the Commission to submit proposals on matter on which it considers that a Union Act is required for the purpose of implementing the treaties. Another means of acting their influence is through the budgetary process, both on the multi-annual financial frameworks by producing reports and recommendations and questioning the Council and Commission, holding debates and votes, and on the annual budgets. They propose amendments to compulsory and non-compulsory expenditure and have the right of approval of or rejection with the Council over the whole budget. Lastly, there is control and supervision of the executive. So they have a wide range of powers in this matter, which allow to oversee the other institutions and monitor proper use of the EU budget and ensure the correct implementation of the EU law. Now, going to the EU's legislative procedures and the European Parliament. We have, first of all, the consultation procedure. The European Parliament is asked for opinion on the Commission proposal for legislation. The opinion can be either accepted or not, and amendments can be made to it. If the decision of the Commission and Council are, however, rushed before the EP gives their ruling, the Court of Justice of the European Union can rule it as invalid. Then we have the ordinary legislative procedure. It is the standard EU legislative decision-making procedure, and it gives equal weight to the European Parliament and the Council of the European Union. It applies to a wide range of areas, from immigration to climate change or consumer protection. And the EP has a right to veto these legislative proposals. Thirdly, we have the consent procedure. So the Parliament's approval is required, especially in cases of accession of new EU member states, international treaties, and citizenship-related issues. This consent procedure is also used in the final decision on the appointment of the European Commission, and the EP has veto powers, but it cannot make amendments. So generally, I identified three weaknesses. The EP does not have full legislative powers. Unlike national parliaments, it cannot have a final say over what becomes law. And the Council can also decide not to take action on the proposals which it does not like. Secondly, the EP, even though it attempts to deliver opinions on time, can sometimes face preliminary deliberations of the Council and with the excuse that they are pending the opinion of the European Parliament. Thirdly, the EP does not have full powers over the administrative legislation, even though numerically it makes up most of EU legislation. The second institution I want to talk about is the Court of Justice of the EU. It plays an important role in shaping, making, and interpreting EU law, and it consists of two courts, both located in Luxembourg: the Court of Justice and the General Court. In most aspects, they are organized in a similar manner. There used to be a third court, the European Union Civil Service Tribunal, which dealt with internal EU staffing matters, but it was incorporated in 2016 in the General Court. The Court of Justice is the more senior of the two courts as it deals with issues of constitutional or political nature. Also, general court judgments are subject to appeal to it. The Court of Justice consists of 27 judges, one from each member state, which are assisted by 11 advocates general. The General Court also used to consist of one judge from each member state, but as there is an increasing number of cases in the last time, the court's membership has been increased so that in 2019 it reached 59 judges. In the past, the member states could nominate judges to both the Court of Justice and the General Court, and the nominations were automatically accepted. But after the Lisbon Treaty, this is no longer the case because the membership of the General Court is being increased, and there has been a precedent of unfavorable opinions on the candidates due to mostly their experience. So, what are the actors involved in the Court of Justice? First of all, we have judges, and the judges elect one of them to be the president of the court for a term of 3 years. His main function is to see the overall direction of the work of the court. And these judges are assisted by advocates general, and they examine the issue and take into account the relevant law and present conclusions. The main organizational difference is that the General Court has no appointed advocates general, and the judges undertake these functions, but they are not allowed to participate in the judgment of the cases in which they work in that field. In the Court of Justice, over half of the cases are dealt with chambers of 5 judges, and in the General Court, around 85% of the cases are dealt with chambers of 3 judges. Most of the work of the court is dealt outside of the public eye, and public hearings are very, very seldom. So what cases come before the courts? The most important cases are called direct action cases, and they help set important case law. The courts cannot initiate action, they must wait for cases to be referred to them, and the Court of Justice's main role is to deal with matters that are of considerable importance to the EU legal order. They deal with failures of member states to fulfill obligations, preliminary references from courts in the member states, and appeals against the General Court decision in direct action. The General Court is charged with dealing with matters that are generally more routine in their nature, as annulments, failures to act, disputes relating to compensation for non-contractual liability, and staff cases. No more details about these cases. We have preliminary reference. It helps the state make correct judgments in accordance to EU law. All the cases come for a preliminary ruling to be given the Court of Justice. However, the court cannot make a pronouncement on a case that happens to have come to its attention unless a reference has been made to it by the appropriate national court. Interpretations are to be accepted and applied by the national court that has made the referral. Then we have failure to fulfill an obligation. Under the Articles 258 and 259 of the TFEU, the Court of Justice rules on whether member states have failed to fulfill obligations. The Commission is more often than not the initiator, but also member states can do that, the latter being more unusual as the state avoids usually public confrontation. The state has to be given an opportunity to submit observations and deliver a reasoned opinion. Only if this fails can the matter be referred to the court. In practice, however, these matters are settled before they come to the court. Then we have application for annulment. So the General Court deals with most important cases of annulment, and it cannot conduct reviews on its own initiative, but only in response to actions brought by a member state, the EP, the Council, or the Commission. Reviews may be based on the following grounds: lack of competence, infringement on an essential procedural requirement, infringement on the treaties, or any rule of law relating to the application or misuse of powers. Then we have failure to act. Under the TFEU, should any of the EU institutions fail to act on a matter provided by the treaties, the member states and the other institution and restricted circumstances, natural or legal person, it may initiate an action under Article 265 to have the infringement established. Lastly, we have action to establish liability. So in the case of non-contractual liability, the Union shall, in accordance with the general principles common to the laws of the member states, make good any damage caused by its institution or by its servants in the performance of their duties. Under Article 268, the court have is exclusive jurisdiction to decide whether the union is liable, and if so, whether it is bound to provide compensations. Shortly to the limitations, one of them is that the gap between cases being filed and cases being decisions being issued is huge. Sometimes due to delays in translation of all the documents in all official languages, high lawyer fees, use of majority voting, which causes lack of concession in some rulings. But nonetheless, the EU courts have played an extremely important part in establishing the EU's legal order. This is because between them, they exercise very, very important roles that are usually filled by the national institutions. What can be said is that the law is far from clear or complete, as the EU is relatively new and is continuously developing, which can become problematic in cases of first instance, cases of appeal, or cases involving rulings on the points of the EU law that have been referred to by national courts. But the cases themselves help clarify and complete the law itself. Now, food for thought. First of all, national sovereignty. How is it endangered by these institutions, and what is the future of the EU law? We have seen cases in which the EU law is being expanded into as the EPPO, European Public Prosecution Office, which deals with white-collar crimes, aspect which was dealt with by national courts before. So this is an info slide for you to think about it. Second of all, in the context in which EU law is still quite vague in some areas, is the primacy over the national law still reasonable? These are my two questions. I'm happy that you listened to my presentation and I hope you enjoyed it. And in case you have any questions, feel free to ask. These are my references, and I hope you will have a nice day. Thank you.